I guess I'm not sure if I need to stipulate to that fact on the record. Um, Can you give me just 1 second, please? Sorry, Your Honor, I'm ready to proceed. Um, I just needed a minute to.
That's fine, Ms. On. Go
Um,
ahead.
so Your Honor, I don't want to necessarily stipulate to the probable cause, but it's not something that we need to address in the hearing. So Ms. Payne, if you wanted to just, stick
All
to
right.
the issues that I mentioned in my motion, that's fine. But I just didn't want to stipulate just in case something were to come up during the hearing.
Okay, probable cause at this time, we're moving forward past that point.
Correct.
Then at this point, the state would just call the officer who read the Georgia implied consent, which is Officer Flournoy. I believe that's how you pronounce the name.
All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right. Officer Flournoy, you're before the court on State of Georgia versus Mitchell, and state your witness.
Yes, Officer Flournoy, can you state your name, please?
Officer Esplanori,
Oh, I apologize for mispronouncing your name then. And where do you work, ma'am?
Clayton County Police Department,
And how long have you worked there?
about 3.5 years.
And are you post-certified?
Yes.
Were you post-certified on April 20th of 2023?
Yes.
Were you on duty that day?
Yes.
Did you respond to a DUI investigation to help out?
Yes.
And when you arrived on scene, what did you do?
I stood by as Officer Sergeant Ward finished her investigation. Once she had finished it, I placed the offender in handcuffs, and then I walked her to my vehicle.
Yeah. And when you placed her in handcuffs, did you let her know that she was being arrested for DUI less safe?
Yes, Sergeant Ward did.
Did you then read implied consent to her?
Yes, once we walked her to the car, once I walked her to my car, and then I placed her inside, and then I read her implied consent.
All right. And what section of it did you read?
For under 21, I asked her how old she was. She stated she was 20 at the time, and so I read her implied consent under 21.
And approximately when did you read it?
About the time, probably within 3 minutes of handcuffing her, from walking her from the front of the vehicle to my rear vehicle.
Okay. And was this during the nighttime?
Yes.
And how many times did you read implied consent to her?
Twice.
Why did you read it to her twice?
First, I read for breath. However, the instrument was down, so I reread for blood consent.
And now I am Can you see this, officer?
Yes.
Do you recognize this?
Yes, it looks like the implied consent card.
And is it an accurate copy of what you keep in your pocket?
Yes.
Where? Is that the implied consent card that was in effect at the time of the arrest?
I'm sorry, reread. Can you say that again?
Is that the implied consent card that was in effect at the time of the arrest when you read it to her?
Yes.
And did you read it to her verbatim?
No, I changed blood to breath so that way I wouldn't confuse her when I was reading it the first time, and then the second time I changed breath to blood so that way I wouldn't confuse her as far as which which test I was consenting for.
So let me ask, you read the implied consent 2 times.
Yes, ma'am.
The first time you read it, you asked for breath.
Yes.
The second time you read it, you asked for blood.
Yes.
Okay.
Okay. And you stated that you designated which test you wanted to run so you wouldn't confuse her. Is that correct?
Yes.
All right. And Your Honor, I'm not really sure how to do this over Zoom, but
Share your screen. What is it you're trying to do?
just admit the implied consent card into evidence. I just don't know how to do that over Zoom.
Okay, do we have an issue stipulating to the implied consent card? And then she can upload it, the copy that she has, and that'll go to Miss Martin.
Your Honor, no objection. I'm assuming that it's the correct implied consent card.
Okay, yeah, so you'll just scan it, just have someone scan it, and then we'll upload it and send it to Miss Martin.
I've already scanned it to myself.
Oh, okay. Share
I
your
just didn't
screen.
know who to send it to. Well, I can open it up and share the screen, I guess, if I can figure out how to do that.
Then there's a video record of it, and I believe Miss Martin also records.
Okay, well, I can try to figure out how to share my screen.
There's a green button at the bottom of the Zoom that says share screen. Choose the yeah.
Okay.
There you go.
Y'all see it?
All right. Is that the implied consent card that you read, Officer Flournoy?
Yes.
Okay, and there's a part that says over 21, age 21 and over, and then there's an under 21 part.
Yes, I read the under 21.
And do you see both of those represented on the screen?
Yes, I do.
All right. All right. So the court will accept the card as Exhibit 1 for the state.
Okay. And am I good to stop sharing it now?
I'm sorry.
Am I good to stop sharing my screen now?
Yes, ma'am. Mhm.
Give me 1 second because the custodial staff is.
Mr. McKay, can you please press mute?
Gotcha.
I apologize for that. And Officer Lenore, after you read implied consent, what was the defendant's response?
The first time or the second time?
Let's start with the first time.
She said yes.
And the first time you asked for breath, correct?
Yes.
And then the second time you asked for blood, is that correct?
Yes.
Okay, what was her response to you asking for blood?
She said, and then she went directly into asking for her, I believe her dad or her stepdad.
Okay. And after she agreed to blood, did you then take her to the medical at the jail?
Once she agreed, I allowed her to talk to her parents who was on scene, and she also called her dad on the phone. And then once she got done talking to them, I transported to Clayton County Jail.
And
Oh. Go ahead.
I was just gonna ask, when you transported her to the Clayton County Jail, did a nurse draw the blood?
Yes,
And did she tell the nurse that she also was going to agree to do the blood draw?
when she started talking to the nurse, I believe she made a statement, said she didn't want to do it. And then, so she stopped. And before we could start, we was talking to her. I said, okay. And I was telling her license is about to be suspended. And then she interrupted me and said she'll do it.
And after she re-agreed to doing it, did you then get the blood kit drawn?
Yes.
Thank you, ma'am. No further questions.
Cross-examination.
Thank you, Your Honor. And is it, I wrote it down, trying to do it phonetically. Is it Flanor?
You can say Flanor, that's fine.
Flanor.
However you want to pronounce it, that's okay.
Well, I'll just say officer for now. So, so you witnessed most of the interaction between my client and Sergeant Ward, correct?
I witnessed the latter end when I arrived to the scene.
Okay. And at that point, when you arrived, you knew it was a DUI investigation, correct?
Yes.
And at that point, about how many DUI investigations had you done?
Have I done?
At that point?
I'm not sure.
Okay. But this wasn't your first DUI investigation, correct?
No, and it wasn't my investigation. I was just assisting at whatever Sergeant Ward needed.
Sure. And you've been trained on how to conduct a DUI investigation, correct?
Yes.
Or to assist in one. And part of your training includes how, why, and when you're supposed to read implied consent, correct?
Yes.
Okay. And you're trained that it's important to read implied consent accurately?
Yes.
And are you trained to read it word for word?
Yes, on the card, yes.
Okay. And that's because if you don't read it accurately and the suspect or offender responds, they may be falsely acquiescing to or refusing a test, correct?
Yes.
In other words, they may not understand what they're consenting to, correct?
Are you talking about as far as like reading the card?
Correct. So if you don't read the card correctly, they may not understand what they're either consenting to or not consenting to. Is that correct?
I'm not sure how they perceive it, but as I read it to them, hopefully they can perceive it as I read it.
Okay. Let's see. So the first time you attempted to read implied consent to my client, so shortly after you placed her in the back of the patrol vehicle, correct?
Yes.
Okay. Your Honor, do I have permission to share my screen?
You may.
Okay. Oops. Now, officer, do you see my screen?
Yes.
Okay. I want to make sure I have my desktop as well as the appropriate screen. Do you see the video of what looks like your body camera? Is that what you see on the screen?
Yes.
Okay. And is this an accurate depiction of your body camera from the night of the incident?
Yes.
Okay. Your Honor, permission to admit this as Defense Exhibit 1.
right, any objection from the state?
No, Your Honor, there's no objection.
All right, will be, the video will be, Defense Exhibit 1.
Thank you.
You may continue.
All right. So, officer, I'm going to go ahead and play your reading of implied consent to my client. Can you
Give me one
hear?
second. I'm gonna read
I just want to make sure you all can hear.
something to you, okay?
Were you able to hear that?
I can hear it.
You can, Miss Payne?
Yeah, I can hear it.
Okay, officer, are you able to hear?
Oh, yes, I can.
Okay, I just wasn't sure. Okay.
So I want you to, can you understand me?
Yes,
So,
ma'am.
okay, I just want to read something to you real quick. So you're 20, so I'm reading you implied consent notice for people under the age of 20 years old, okay?
Mhm.
The state of Georgia has conditioned your privilege to drive upon the highway.
Your Honor, it's loading. Your Honor, if I can have a minute to refresh my screen, it's not.
You may.
Thank you.
Dispatch.
Next year. I don't. Next year.
One right now. 20 right now. All right, got you. Give me one second. I'm
I
gonna read
don't
something.
have no. I don't have my license.
Okay, that's fine.
My mother.
Give me one second. I'm gonna read something to you, okay? So I want you to, can you understand me?
Yes,
So,
ma'am.
okay, I just want to read something to you real quick. So you're 20, so I'm reading you implied consent notice for people under the age of 20 years old, okay?
Mhm.
The state of Georgia has conditioned your privilege to drive upon the highways of this state upon your submission to state administered chemical tests of your breath for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial. If you submit to testing and the results indicate an alcohol concentration of 0.02 grams or more, your Georgia driver license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to the requested state test, you are entitled to additional chemical tests of your breath at your own expense and from qualified personnel of your own choosing. Will you submit to the state administered chemical test of your breath?
Yes.
Okay.
Okay, officer. So at this point in the video, you would only ask my client if she would submit to a chemical test of her breath, correct?
Yes.
And you admitted the part in the applied consent card that mentions blood or urine, correct?
Yes.
Okay. And at that point, she had only given consent to test her breath, correct?
Yes.
Okay. And as you mentioned before, before you transported my client to the Clayton County Jail, you read implied consent to her again, correct?
Yes.
Okay. Your Honor, if I may have permission to share my screen again.
You may.
And officer, do you recognize this video that I have on my screen?
Yes.
And how do you recognize it?
That's my hand and my body cam.
Okay. Your Honor, permission to admit this part of the video as defense exhibit number 2.
Any objection from the state?
say I object, but once the video was admitted, the whole portion of the video was admitted, so I don't know if there's a need to admit it again.
Yeah, is there an interim? Is there something that happened between the first part, which was admitted as defendant's exhibit 1, and this part?
I'm sorry, Your Honor, are you asking if there's,
Yeah, if this is a continuation of exhibit 1, then there's no need to readmit. If there was some break in the action where exhibit 1 was cut off and then something happened that we didn't see, and then exhibit 2 is starting at a separate point, that's another thing. But if this is just a continuation of exhibit 1, we're fine.
okay, Your Honor, we'll keep it as exhibit 1, I apologize.
Okay, thank
and so
you.
we'll start-
Thank you, Ms. Payne. Go ahead, Ms. Hahn.
Okay. And so I'll go ahead and play, officer, this portion. And I have to refresh my screen. Give me 1 second. I apologize. Are you all able to see the video again?
Woo! We saw your desktop, but that was a lot.
I apologize, Your Honor. If you all, are you all able to hear?
Huh?
Yes.
Okay. All right.
No, you got to stay inside the car though. So I'm gonna reread you this, and it's just gonna change, okay? The state of Georgia has conditioned your privilege to drive upon the highways of the state of Georgia upon your submission to a state administrative test of your blood for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be used, offered into evidence against you at trial. If you submit to testing and results indicating alcohol concentration of 0.02 grams or more, your driver's license or privilege to drive on the highways of this state may be suspended for one minimum period of 1 year. After first submitting to your required state test, you are entitled to additional chemical tests of your blood at your own expense for qualified personnel of your own children. Will you submit to the chemical state test of your blood? I changed it from breath to blood because our blood machine is down. So it's just for your blood, okay? I think your dad's up.
So, officer, in that portion, you would ask my client if she wanted to submit to a chemical test of her blood, correct?
Yes.
She never said yes, did she?
Well, I heard her say and then go directly into speaking about her dad or stepdad.
So, in the video, as soon as you finished reading, you spoke again, and
Yes.
then she asked, correct? About
Yes,
her dad.
I spoke again to let her know I changed it from breath to blood, and then she spoke.
And then she immediately asked to speak with her father, correct?
She said, from what I heard that night, and then went to asking for her dad or her stepdad.
Okay. But you didn't hear clearly from the video, did you? That you just heard?
That I just heard. Well, it seems like it's still the same thing from the night when I was out there on the scene. It seemed like she was saying, she said, and then she went directly into asking for her stepdad
Okay.
or her dad.
Okay. Your Honor, if I could share my screen again.
You may.
Thank you.
For the purpose of determining if you are under the influence of alcohol or drugs, if you refuse this testing, your driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial. If you submit to testing and results indicating alcohol concentration of 0.02 grams or more, your driver license or privilege to drive on the highways of this state may be suspended for one minimum period of 1 year. After first submitting to your required state test, you are entitled to additional chemical tests of your blood at your own expense for qualified personnel of your own children. Will you submit to the chemical state test of your blood? I changed it from breath to blood because our blood machine is down. So it's just for your blood, okay?
So, officer, now that you've heard it again, you see that she never agreed to a chemical test of her blood, correct?
Your Honor, at this point, I would object because the question has been asked and answered, and the officer has responded multiple times that she heard the defendant say, and then go in to asking for her dad or stepdad.
Courtroom.
So, officer, my question was, now that you've heard it again, you didn't hear her ever consent to a chemical test of her blood, did you?
It might be difficult to hear in the video, but I heard her say, and then she went directly into asking for her stepdad or her father.
Okay. But you heard her previously in the other video say yes to consenting to her breath, correct? The test of her breath?
Yes, and so when I was going to put in my applied instant card back inside my vest, you heard a little shuffle. That shuffle could have been mistaken. They could have heard her clearly, but I know I heard her say and then go directly into asking for her stepdad or her dad.
Sure. Okay. And later you transported my client to the Clayton County Jail. And you met with the nurse there, correct?
Yes.
Okay. And then again, she asked if she had to have her blood drawn, correct?
She was speaking to the nurse. I believe that's what she said. And
Okay.
then as I turned around, I explained to her, okay, if you don't, well, your license will be suspended. And as I was going to get ready to walk out, she interrupted me and said she'll do it. And that is when the nurse proceeded with it.
Okay. And while you were in the room where the blood draw was to take place, you told her that she had already consented to a blood draw, correct?
I told her, I don't remember saying that exactly like that, but I do remember saying, like I said, your license will be suspended. And then she interrupted me and said she'll do it.
Okay. All right. If Your Honor can have a moment, I'll share my screen again.
Any type of, legal advice, actually, okay. Like I explained to you, I read you the card, implied consent card, you agreed, but now you're refusing, so the license will be suspended. It's up to you, it's your decision.
Oop. So, officer, at that point, you said, quote, like I explained to you, I read you the card, implied consent card. You agreed, but now you're refusing. So your license will be suspended. That's what you said, correct?
Yes.
Okay. But she never agreed to a chemical test of her blood, did she?
Well, like I stated earlier, I heard her say uh-huh and then go directly into asking for her stepdad. So when she said uh-huh, I took that as an agreement. She never defied or anything like that while we was standing there talking on the side of the road.
But it was clear that she agreed to a a breath test, correct?
Yes.
Okay. And officer, it's true that you can apply for a warrant to search for my client's blood, correct?
I wasn't the arresting officer, so I don't have that privilege.
No further questions, Your Honor.
All right, I have a question that nobody seems to be asking. Why, when you get a consent for breath, did you read implied consent again and change the test?
The instrument was down at the time. We was using Jonesboro Police Department and toxilizer. However, the instrument was down. So once I found out, I reread for blood.
All right, any other questions?
None from defense, Your Honor.
I have a question, Your Honor.
Uh-huh.
Officer, so you testified on direct and on cross that you heard the defendant say uh-huh to your reading of the implied consent asking for blood. Is that correct?
Yes.
And you testified to the fact that you even hear it on the video. You just can't hear it as well. Is that correct?
Yes.
Are the ears that you had on scene that night going to be able to hear more of the defendant's statement than the quality of the video that we have from all the background noise?
Yes.
Are you sure that she did give consent to her blood drawn?
Yes.
Thank you. No further questions.
All right, anything else for Officer Flournoy?
Nothing from the state.
All right, anything else from the defense? At this time, may this officer be excused?
Nothing else from defense, Your Honor.
The officer may be excused. I do have one more witness, though, Your Honor.
Okay, yeah. The state may present its next witness. Officer, you're excused at this time. Thank you.
The state would call Miss Sharon Brown to the stand.
Come here. All right. Ms. Brown, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right. You can put your hand down. You're before the court of State versus Mitchell. You are here on behalf of the state. Ms. Payne, your witness.
Yes, Your Honor. Ms. Brown, can you state your name, please?
Sharon Brown.
And where do you work, Ms. Brown?
I work at Clayton County Jail.
And what is your job capacity there?
I'm the Health Services Administrator.
Do you supervise and maintain the record of the nurses that are on staff at the jail?
I do.
The procedure that your nurses have there, to the best of your knowledge, do all your nurses follow it to the best of their ability?
Yes, ma'am.
If a defendant is brought in on a implied consent blood draw, will the nurse draw the blood if the defendant then refuses and says, no, I don't want the blood
No, they
drawn?
will not.
Is it against policy to draw the blood if the defendant actually refuses it?
No, we cannot do that. No.
So you have a
A
policy that,
policy, yes, yes. We
Okay.
cannot force anyone to do anything, right?
and you said to the best of your knowledge, your nurses comply with that policy?
Yes.
Are there repercussions if the nurse does not comply with the policy?
Yes.
What's the repercussion?
You cannot force anyone to do anything, even take medications or anything. If so, you can lose your license. You cannot force them. Yes.
And to your knowledge, Natalie Chance, the nurse in this case, her license is still valid?
Yes. Mhm.
Thank you, ma'am. No further questions.
All right, cross-examination?
Yes. Ms. Brown, when did you start working as a nurse supervisor?
About almost 2 years, not quite, like a year and 8 months.
Okay. Do you remember your start date?
November 7th, 2022.
Okay. All right. Nothing for this witness, Your Honor, or nothing further for this witness.
Okay. All right.
There is no redirect, Your Honor. This witness may be excused.
All right, Ms. Brown, you're excused at this time. Thank you.
Thank you.
All right. Any other witnesses for the state?
Since Ms. Owens stated all she was attacking was the implied consent, no, there's no other witnesses. State would rest
All
at this
right.
time.
Any other witnesses on behalf of the defense?
No, Your Honor, I would just ask for about a minute or two, for argument. I have my argument. There was an issue with my printing, so I just need to pull up my bullet points if that's okay.
All right.
Thank you. Right, Your Honor, I'm ready. I apologize.
All right, go ahead.
I'm sorry, is it the state is reserving?
That's correct. I'll just reserve the right to.
Okay. So Your Honor, under US and Georgia law, this requires that a search of my client's blood be performed with a warrant, but absent a warrant, an exception to the warrant requirement should apply. The state's contention is that the warrant was not required under these circumstances because Ms. Mitchell consented to the search of her blood. However, Ms. Mitchell never consented to the search of her blood. The state conducted an unlawful search of my client's blood in violation of Fourth Amendment rights, and any evidence obtained from that search should be suppressed. As the court saw in the video, first implied consent was read by Officer Flournoy, but only as it concerned my client's blood. My client, as the court heard, gave a loud and clear answer that she would consent to a search of her, of her breath. She gave a clear answer that she would consent to a search of her breath. However, when Officer Flournoy came back and read implied consent as it applied to her blood, my client did not, it's our contention that she did not consent at all. We believe that as soon as the officer finished reading implied consent, she didn't even give space for my client to respond. She immediately said, oh, well, I just had to, and this isn't a direct quote, but I had to reread it to you because it's for your blood. Didn't give my client time to respond after asking if she would consent, just corrected herself. And then my client, as you saw in the video, kind of stared off a little bit and then asked to speak with her father. She never gave a consent to her blood. And then again, when she was in the room with the nurse for the blood draw, she showed again that she did not want to consent to her blood. There was a clear consent to giving a test of her breath, but never to her blood. In that case, officers should have applied for a warrant for her blood if they wanted to get her blood. Furthermore, it is State v. Henry, believe that says that when there is any ambiguity, which we don't believe that there is, that the ambiguity should be construed in the driver's favor. And so, Your Honor,
What's the site?
Pull up for you, Your Honor. State v. Henry. Why does it say that? Sorry, Your Honor. That's what I was trying to pull up before I. Let's see, Your Honor, it's 36. I think it's State v. Henry, Georgia. I'm sorry, Your Honor. I can't find the site anymore, so I apologize, Your Honor. I'll just withdraw that from my argument. But nevertheless, Your Honor, implied consent was not read properly. My client never consented, as we saw in the video, and therefore we believe that the chemical test of my client's blood and any evidence that came from it should be suppressed.
All right, State.
Yes, Your Honor. The state would contend that the officer did do as the law allows for implied consent, even in the implied consent statute for OCGA 40-5-67.1 and B right under 3, it doesn't have a number listed by it. It says, if any such notice is used by a law enforcement officer to advise a person of his or her right regarding the administration of chemical testing, such person shall be deemed to have been properly advised of his or her rights under this code section and under code section 40-6-392, and the results of any chemical test or the refusal to submit to a test of such person's blood or urine shall be admitted into evidence against such person. Such notice shall be read in its entirety, but need not be read exactly so long as the substance of the notice remains unchanged. The officer did testify that the reason she asked for breath and then blood is so that the defendant would not get confused about which test she was specifically requesting for. In addition, Eberly v. State, which is 240 Georgia Act 221, actually states that a refusal to take a state administered chemical test could be admitted since there was substantial compliance with the implied consent notice informing defendant that he was entitled to secure additional testing. So not having it just read verbatim is not a strict law to get the implied consent and the bloods out, because the purpose of the law and even in the legislature purpose is that the defendant be have a substantial understanding of what is being asked of him or her and what is being required. And
Okay, so this is my concern, Ms. Payne, because even the way that the current case law trend, it initially kind of like treated breath and blood somewhat differently, but it's trending to give more deference for both tests. But here's the issue. So we're hearing the first consent being read in its entirely. She's asked for breath. She agrees. Then the officer comes back almost immediately, reads it again, asks for blood, and at that time, she's distracted. She's talking to someone else, but there was no distinction made that, hey, I'm not just rereading this to you. The test is changing, and it was like back to back. So if she agreed to breath, then there should have been no need to read another test. But if she's going to read the other test, there was no information given to the defendant that, hey, I'm reading this test. I'm not asking you for blood this time. I'm asking for breath because there was an issue. Not that in the compliance issue, you know, like I'm reading the same card. It's the same information, but the test issue, because the way the tests are treated under the state is a little bit different, but also you're asking someone not to just blow into a tube, but you're asking someone to submit their arm to be punctured by a needle to get a test. So in that sense, I'm asking because this is the first time I've had a case where the implied consent is completely read for one test and then it's completely read again for another test. And so my issue is, if she agrees that she's willing to take a breath test, that agreement is different than if she can fully agree, hey, I'll be fine to blow into a tube. But she can also say, yeah, but I'm not cool with that blood. And so when an officer makes a decision about what test they're asking about, I'm not clear that she was clear that there was a change from, yeah, I'm agreeing to blow into a tube to, yeah, I'm agreeing to let you puncture my arm and take blood.
Your Honor, the state would contend that the officer did testify, and you even saw in the video that at the end of her reading implied consent, she actually stated that the only thing I'm changing is now I'm requesting blood and not breath. So the state would contend that the defendant was put on notice and was aware that she asked for blood and not breath, because she repeated it multiple times within that implied consent warning and then said, I'm just asking for blood instead of breath. The state also contends that when the defense even showed her at the nurse's office that or that at the jail, that she was getting up ready to give blood, and the officer testified to, oh, well, when she was talking to the nurse, she said, I didn't want to do it. And I was like, okay. And then re-explained, well, I read implied consent for blood. You had done agreement and now you're refusing, and that's fine. It's your choice. So,
I get that, but before she says it's your choice, and the part that nobody mentioned is I heard a conversation going on where someone mentions jail. And I didn't know, because of the quality of the video, I didn't know if that was Miss Mitchell asking about whether she was going to jail or whether the nurse discussing jail, but I heard jail. And then right after that, it was the discussion of, well, if you don't want to take the test, then your license is going to be suspended, but it's up to you. So in other instances, the fact that the license suspension part is restated once a person initiates a refusal can be seen as being somewhat coercive.
the state would contend that after you just said it's up to you, that there's nothing in the case law that says that it is coercive, and that Jackson v. State actually just says it's a totality of the circumstances of involuntary consent, and that her initial agreement to it can lead to it also designating it as voluntary, and the fact that she was aware that she could refuse it, that she was aware that there was no threat or of anything, and there was no threat of lengthy detention or anything like that. It was just, the state's contention on that was she was already at the jail. She was already in the position of, she knew she was going to jail. It's not like she was thinking that this would now get her out of jail, because that was never promised to her. She was sitting in jail with the jail nurse. Miss Brown even testified to that the policy of that is if they refuse and they say no and they don't want to do it, we can't do it. We don't do it here, because that will make our license suspended. She testified to that Natalie Chance, which is a nurse on the case, license is current. So there was no refusal in this case, and she was aware of her what test was asked of her, and she was aware that she could have her own other chemical test done, or she could refuse it, and she chose to let the nurse draw her blood.
Last thing, no ma'am, Miss Mitchell, What is the substantial difference between the over 21 card and the under 21 card that was read in this case?
The over 21, the only difference is that it will say 0.08 grams and the under 21 says 0.02.
All right. Ms. Payne, did you have anything else on behalf of the state?
No, Your Honor.
All right. All right. So the court is going to take this under advisement and will issue a written order so that you all may proceed from that point. All right. Thank you all. Ms. Mitchell, the reason I said no, you can't say anything is because you have the right, the Fifth Amendment right against self-incrimination. I do not want you to mess up your defense. Anything that you need to discuss, please discuss it with Ms. Hahn. Ask her any questions that you have about this hearing or about anything in this process, but please don't disclose anything to anyone else other than Ms. Hahn as part of your defense, okay?
Your Honor.
All right. Thank you, ma'am. All right. You're free to go at this time.
All right, thank you. Have a nice day.
All right. You too.